Hey, everybody, and welcome to Chapter 5 Criminal Law. I'm having trouble with some of these PowerPoint slides, so I'm trying this a little bit differently to see if we can do this. So they don't want to do right, but so we're going to see how this works, if it works better than now it is. Now it's working. All right. So Chapter 5 Criminal Law. I'm not a lawyer. I stayed at a Holiday Inn Express one time. I did get my bachelor's degree in criminal justice, and sometimes there's not a lot of things that have changed about criminal law since then. But and I know that one of our learned colleagues in class, Adam Kersey, would be able to do this much better than I. So Adam, be sure and correct me if I say and do things that are wrong. But we just want to look at some of the criminal law um, aspects or things that we would be in public safety would be exposed to. So we're going to distinguish between violations of civil and criminal law and between felonies and misdemeanors. Identify three elements that make up a crime. Explain why an omission can give rise to criminal liability. Identify four criminal mental states. Identify the elements of some of the following crimes from murder, involuntary manslaughter, assault, sexual assault, rape, and child molestation, larceny, robbery, um, RICO, embezzlement, false imprisonment, and of course, arson. We all know that there is a difference between criminal and civil law. When we're talking about criminal law, these are crimes, and these are activities that violate a law, and an offender is penalized. In this, you can see in this chart the differences between criminal law and civil law. In criminal law, the charge is brought by the government, and the burden of proof is beyond a reasonable doubt. We do give a lot of leeway to the offender, and they can be jailed, probation, fine, or restitution as a penalty. The goal of criminal law is the vindication of the wrongdoer. We want to prevent future bad acts. Now, civil law are those laws that where one party can bring an action against another party who has been wronged in some way. Again, this can rise out of the same act. I think I used O.J. Simpson in another example, and this is probably another place where we can use him as an example. Um, Certainly, civil law has a different burden of proof, that more likely than not, and usually it's money damages or a court order in some way. So, civil law is brought by an individual or a corporation or an organization, not by the government. When we look at the definition of a crime, there's statutory crimes, there's common law crimes. Common law crimes go back, you know, years. There's some that still exist in some jurisdictions. Your book uses the example of common law arson. Under common law, it had to be the dwelling of another, and it had to be willful and malicious. So, if you burn down somebody's barn, it wasn't arson under common law. And we know that those things have been um, fleshed out as far as requirements for different type of common law crimes. Um, and then, of course, statutory crimes are those that um, have that are legislated crimes or case law against what we refer to as against the law. And the violation of the law is not criminal unless the law says it is. So we have to have laws in place to make those things criminal. Some of the reasons for criminal punishment, like we said, we want deterrence. We want to protect society from any more wrongdoings or incarceration through incarceration. We seem to need that justice, eye for an eye. It seems to be there. So we want to vindicate the victim, vindication of the victim in society. We want justice. A lot of times it leads its way into wanting revenge. But certainly for the deterrence and the protection of society is very important. Now, when we're talking about different crimes, there are two different levels, as we all know. There's felonies, which are punishable by more than a year in jail, and misdemeanors, which are less serious. Those are punishment by 1 year or less in jail. So those are the two categories. Usually, of course, your felonies are your more serious offenses. Sometimes states look at the dollar amount. I think in Georgia, it's $1,000 makes it, if it's less than $1,000 penalty, is a misdemeanor. Over that, the penalty for felonies is more than that. I think that's what it is. One of the biggest things we want to talk about is the elements of the crime. Um, these are often defined by the statute or the case law as what makes a crime a crime. It's made up of different elements. There's the act, there's the mental state of the person, there's attendant circumstances. Those are the three elements of the crime. And so we're going to look at all three of those. This can be an affirmative act or omission. And in looking at this, it's either something that you did or something that you failed to do, that you did not do that made it a crime. And if it was involuntary, cannot be the basis for criminal liability. If someone has a gun to my head and I rob a bank because they have a gun to my head, I can't be held liable for that. If I know that the gun's not loaded and we're doing this to pretend, then yeah, I can be held liable for that as a part of a crime. So the affirmative action that meets the requirements, um, such as in arson, starting a fire. That is that affirmative act. And then omissions and duty to act. Now, this is where it can get a little dicey for I'm going to go back, dicey for our emergency responders. Is that we have a duty to act when the alarm rings or we're sent on an emergency call. We have a duty to be there. Um, the common law said that no one has a duty to do anything. That if you can walk down the street and someone's drowning in a puddle of water, then if you walk on by, you're not liable for anything, to come to their aid. But there, like I said, there are exceptions, like a family relationship. Um, uh, they have parents are supposed to take care of their children. Lifeguards are supposed to come to the aid of those that are drowning. Um, and an on-duty firefighter or on-duty police officer has the responsibility to respond to an alarm. So this we're going to talk about this some more in a later chapter, chapter 8. But this duty to act may be something that we all have to think about. So and we're going to look at a court case a little bit later that deals with that as well. So the duty to act, remember it's an act or an omission or a failure to act. Mental state, there's four mental states or four um, uh, aspects that we want to look at. Of course, mental states referred to as mens rea. Um, the specific mental state varies from crime to crime. And looking at those four words on the screen there, purposeful, knowing, reckless, and negligent, you will see that written into the citation when an individual purposefully and knowingly, those are written into that legislation or that crime. Um, Purposeful, of course, means that the person intended or desired to engage in certain conduct or cause a certain outcome. Um, I shot somebody with a gun because I wanted to kill him. That's purposeful. I meant to do it. Knowingly means that the person knew that a particular outcome would follow. Um, the example in the book is, Fred lit his house on fire. The arson investigator found some evidence. He puts it in his car. So Fred blows up the arson investigator's car as he's driving. Um, he didn't really mean his intention wasn't to kill the investigator, but it was to destroy the evidence. But he knew that by blowing up the car, he was going to kill the investigator. So it is knowing the outcome, knowing what's going to happen. That if you set a fire, um, if you set a fire, that it's going to burn down that residence no matter what your purpose is. Recklessness is a mental state that we look at. Again, pardon the going back and forth. Recklessness is a conscious disregard for what I guess a proper person would do from a standard of care, or what a law-abiding citizen would do. Recklessness, and then of course negligence um, is a criminal mental state in which the perpetrator should have been aware that a substantial and unjustifiable risk of harm would result from his or her conduct. Um, so when we look at at statutes, criminal statutes, you will see these words, and that kind of lists the mental state that has to exist. Um, when we talk about which mental state is required, like I said, a lot of times it'll vary from state to state, but the term intentional, meaning that they intentionally cause harm. One of the things I always had problems with was that with juvenile fire setters is that they didn't have the proper mental state. If you've got an 8-year-old kid that sets a fire and it burns down a house, um, uh, there's nothing intentional most of the time with those kids. They they cannot form the proper mental state to be convicted of a crime. So that's one of the things to think about as well. Um, Again, strict liability says that most crimes require proof of a culpable mental state. And again, that's the model penal code. Um, that sometimes minor crimes, maybe traffic regulations, um, usually misdemeanors, may not require proof of the culpable mental state. Those are referred to as strict liability crimes. And it's often, like it says there, a regulatory offense. The focus of the crime is solely on the act itself. The mental state doesn't enter into it. And then the third aspect is attendant circumstances. Um, the other facts that must be proven, that must exist. Um, if you're going to be convicted of assault on a uniformed officer, the officer must be in uniform, or the same thing with a firefighter. Um, if you think about the common law definition of arson, you would have to prove that the building was, in fact, a dwelling house. It wasn't a barn, that people really did live in the barn, or something like that. So you have to make sure that all the circumstances are there. So the three elements, that mental state piece that's so important, um, that there's four parts to that: purposeful, knowingly, reckless, and negligent. And then when we talk about the three parts of the crime, or what it means to commit the act, the elements of the crime, um, the act itself, the mental state, and then the attendant circumstances. Those are the three elements of the crime. So let's look at some offenses. We know homicide is the killing of another intentionally without justification. Um, most states recognize first, second, and third degree of murder. Um, that murder is first degree murder is committed with malice aforethought. I always liked that phrase. It refers to the fact that it was premeditated. They thought it out. They planned it. Um, any murder that's committed without that is second degree murder. That's just an impromptu kind of thing, I guess. Um, Manslaughter, that are homicides that do not constitute murder, can be voluntary or involuntary. Voluntary is the intentional killing of another committed in the heat of passion as a result of severe provocation. Or there's involuntary manslaughter. This results from reckless conduct um, of uh, of an individual, from the reckless conduct of the defendant. So it's unintentional killing um, that occurs. Some people look to, your book gives the example of the Coconut Grove fire. That was supposedly started by the busboy, and that could be looked at as manslaughter or unintentional involuntary manslaughter. So we've talked about these already. The killing with malice aforethought. The mental state is that purposeful, knowing, or reckless, indicating a depraved heart. I love these terms. Again, I'm sorry. Zooming through these, first degree, we talked about. Second degree, voluntary manslaughter, unintentional killing in the heat of passion, and then involuntary manslaughter is the unintentional killing. So battery, we always hear about assault and battery. Battery is the touching of another person without their consent. Um, Consent is a defense. Consent must be knowing and voluntary. It can be implied. And where that becomes of concern for us is when we talk about consent to give care for EMS in our EMS type of situations. Consent must be knowingly and voluntarily given and be free from fraud, mistake, or deceit. It can be implied. Consent can be implied through a social custom, or so when you get into the crowded subway, you expect to be jostled, touch shoulders or whatever, but that doesn't mean that it can get out of hand in the subway. Um, so when we have to make sure that we are thinking about consent when we touch someone, when we provide care for them. We know that consent is implied if the person is unable to consent. We know that consent is implied for a child or a minor uh, to a certain degree. So we want to make sure that we make sure that we pay attention to those things. There we go. When somebody doesn't object to our treatment, now they can withdraw it at any time, as we well know. Um, but consent is implied from the circumstances. Um, don't ever pretend to be something that you are not. Consent that's induced by fraud, deceit, or misrepresentation is not valid, and it's limited by circumstances, meaning that you give the care that's needed, um, and only that. Assault. This is placing another in immediate physical harm. A lot of times we see assault and battery together. This is physical. Physical contact is not necessary for assault. If the assault does become physical, then it becomes battery. Again, consent rules apply. Um, it's, assault of a firefighter in the line of duty or assault with a deadly weapon. Uh, Domestic assaults are an additional category. Basically, this is words. It's physical, like I said, physical contact is not necessary, but the words place the victim in fear of, of battery. False imprisonment, unlawful restraint upon a person's freedom and ability to come and go. Some people call it false arrest. Some say that false arrest is just one type of false imprisonment. Again, where this is not kidnapping. Used to, for it to be kidnapping, they had to take the person, um, limit their freedom or restrain their freedom, and cross a line, take them somewhere. Some jurisdictions don't hold that true anymore. Um, it can be just a short distance, or just simply um, limiting their freedom can be kidnapping as well. Um, think about this again when we're talking about consent and patient treatment. If you take somebody to the hospital that doesn't want to go, and you load them up, put them in the ambulance, that might be considered false imprisonment or kidnapping. Kidnapping is the use of force or the threat of force, and taking someone from one place to another, or secretly confining someone, forcibly carrying or sending someone out of the state. So again, two very closely related statutes or crimes. Rape, of course, is sexual intercourse without others' consent. It used to be under common law. It had a very narrow definition, and it had to be assault that where the man was the rapist, and the woman was being raped, and that's not necessarily true anymore. They've expanded the definition of rape um, to to be the most. Of course, first degree is the most serious. It your gender has nothing to do with it anymore. And then, of course, when we're talking about rape, there are um, child molestation, which is a totally separate situation, totally different charges. Um, so under the modern trend, they've expanded that definition of sexual assault. It is not as narrowly defined as it was for common law. Common law larceny, taking and transporting of property with intent to permanently deprive. There's all kinds of larceny crimes now. Um, Under common law, some people, your neighbor borrows and never brings it back. But that, again, we have to think about the mental state. Did they mean to bring it back or not? Um, Sometimes larceny crimes are charged as felonies or misdemeanors, depends on a lot of times the amount that we're talking about, the amount of money or the amount of property. It's a very basic theft crime, larceny or stealing, just taking a property from another. As we look at some of these broad range of theft crimes, we have embezzlement, we have obtaining money under false pretenses, and then we have robbery. Embezzlement is something that we can run into we run into, or we have seen cases about it, where this is where someone um, who lawfully has possession of another's property appropriates the property for his or her own use. Think about a volunteer fire company that pays dues or does fundraising, and that money is held by the secretary or whoever, and they appropriate the money for their own use. Obtaining money under false pretenses. The first thing that came to mind for me there is these people um, that call up and pretend to be peace officers or firefighters that are asking for donations. Again, false pretenses. And then, of course, robbery is larceny through the use of force or violence, um, taking money or other personal property, um, even through a use of fear. Extortion. Um, I always this in my mind relates or equates to bribery. Obtaining money or property by requiring someone to do something they're not legally required to do, but there has to be some sort of threat necessarily. Usually it's a exposing of some kind of damaging information if the person doesn't pay, but the threat is there. The threat is necessary for there to be extortion. Burglary, breaking and entering is a part of that. Many states have offenses that address some of the loopholes in the common law crime. It was limited to breaking and entering. The dwelling in the common law definition was the limited to breaking and entering the dwelling of another in the nighttime with intent to commit a felony therein. Well, we know it no longer has to be at night. It does not have to be a dwelling. It can be a commercial building, and it doesn't have to mean that there's going to be an additional felony or not. But when we look at dwelling while possessing instruments related to wrongful setting of fires, could be discussed there as well. So there's a pretty wide range of burglary statutes that cover breaking and entering and robbery and larceny. Arson, we all know what that is, the common law definition, the willful and malicious burning of the dwelling of another. We know that it has been expanded to have comprehensive arson laws. Um, Certainly, we want to be aware of the arson statutes in Georgia, and we'll probably have a little exercise with that at some point during the course. First, second, and third degree um, are um, are what we have here in Georgia as far as the arson crimes. When we look at the requirements for arson, there has to be an act, like we said. It's a criminal offense that has some challenging issues sometimes. And it's kind of interesting because when I was reading this in our book, I think about what I would always call and what I had heard referenced as remodeling fires. And they, you know, they give several examples here, but I thought about that where the cat knocked over the candle and ignited the home. And then the person realizes, well, if I don't do anything, then my home's going to burn down and the insurance is going to pay and I'm going to have a brand new house. Um, and so, how does that fit into it? I always use the example of mama that puts her grease on the stove to warm up a little bit, and she strolls down to the mailbox and she talks to the neighbor a little bit, and she comes back inside just in time to see the blaze, and it damages the kitchen cabinets and soots up the walls. She still has all her good personal belongings, but she gets her brand new kitchen with her brand new appliances. So sometimes the crime of arson, as we know, is hard to prove. It's hard to prove. There's a lot of things that go on there. That's what makes it kind of special as well. Racketeer Influenced and Corrupt Organization Act. We I know I've never run across this in my career as an arson investigator or fire investigator, but I know that it is probably prevalent in some areas as far as racketeering activity. It's illegal to engage in that through the use of an organization. And that's what makes racketeering is when we are using using an organization for that. It's any act or threat involving murder, kidnapping, gambling, arson, robbery, bribery, extortion, or dealing in a controlled substance, which is chargeable under state law. Um, it you forfeit. I know a lot of times prosecutors would rather prosecute under the RICO statutes because there's a large forfeiture and it authorizes seizure. There's also civil penalties and liabilities in RICO cases. So that is something to be aware of. Like I say, I've never run across this in in my in my experience, but I'm sure those cases exist. So we've talked about criminal law, the three types of elements, the act itself, the mental state, and the circumstances. And we've outlined several criminal offenses. We look at these criminal offenses as whether, as a police officer, law enforcement officer, we're going to run across those a lot more than in the fire service or in EMS, but they're also things that we need to be aware of so that we can protect ourselves against these, such as consent in giving care and treatment and making sure that we don't cross the line, as they say. And looking at mental state when we're talking about arson. Your book does mention several different aspects of the arson statute where the mental state um, looking at what is required. And again, it's intent. An 8-year-old can't form intent. I don't, that's my personal opinion. Um, but certainly there are other types of offenses where they can. So this is just kind of a brief rundown of criminal law. We're going to do an activity that relates to one of the cases in the book. And then probably later on, we're going to look up some arson statutes and some other statutes. So I appreciate your time. And if you have any questions, as always, please be sure and let me know.